The people are ready, Your Honor. Those are words that the Manhattan DA's office is gearing up to say on March 24th in the Donald Trump election interference case, where he paid a porn star, Stormy Daniels, through his lawyer and fixer, Michael Cohen, and then lied about it, didn't declare it on his campaign finances, and grossed up wages so that he and Michael Cohen could commit tax fraud, and Michael Cohen wouldn't have to claim it, or could claim it as income, but would have more money than he was owed. So it would come out as a wash, and lied about it in business records. That is the case that is going to be going March 24th. Why do I think that case is going March 24th? Because Judge Chutkan stayed her case, and whether or not the case is going to be going in March 4th now is of grave concern, and it might not happen. Donald Trump wants to delay. That's what his tactic is here, so that he doesn't have to face the music. He doesn't want to have to go to trial, so he delays. And he's made a presidential immunity claim, which we've been reporting about, and reporting that this is a big deal. It's not frivolous. And why is that? Exactly for this reason. Because now Judge Chutkan has no choice but to press pause until the appeal of that case and of the presidential immunity issue is resolved. And that is because if he is immune, there's no trial. If he's not immune, there is a trial. It's one of those foundational questions that determines whether or not there will be a trial. And so the law is pretty clear here that in a case like that, when it's something that is so foundational, that would absolutely be outcome determinative, or in this case, whether there be burdens of litigation on the defendant, which there would be if it continued, right? Jack Smith has been filing all sorts of motions. He filed a SEPA Section 6 motion today. He wants to keep going with the proceedings. But Judge Chutkan said she had no other choice but to stop the trial until this is decided. Now, two things have to happen. Either the DC Circuit, Jack Smith anticipated this was going to happen. So even before Judge Chutkan stayed the proceedings today, Jack Smith filed a notice of appeal and a writ of certiorari before judgment to the United States Supreme Court, which basically means, Supreme Court, can we skip a step and go straight to you and have you hear this presidential immunity question? Because if it doesn't go now, it's never going to go. Why is it never going to go? Because what will happen? Stormy Daniels case is going, right? That's how I started this, because that is exactly what will happen. If it doesn't go March 4th, a couple weeks later, Judge Juan Merchan is going to see that the calendar is clear and the people will answer ready, and that will go to trial, and that will take some time. And then it's going to bump into the Mar-a-Lago documents case, and then the election. And then if the election happens and Donald Trump wins the nomination and wins the election, then what happens next? Anything is your guess, right? He could be like Joe Biden is, and not necessarily pardon his son or dismiss the case against his son. No, Joe Biden kept in David Weiss, who is a Trump prosecutor, right? Trump appointed him to the United States Attorney's Office, made him special counsel. And what happened? This sweeping, scathing indictment against Hunter Biden with felonies and misdemeanors of tax fraud. And then there's another gun possession case as well. Do you think Trump's going to do that? Is he going to appoint a special prosecutor to prosecute himself? A, he's not going to do that. And B, you can't prosecute a sitting president. The Office of Legal Counsel of the Department of Justice has said you cannot prosecute a sitting president. So what will happen? It'll either be held in abeyance until after he serves, or more likely, what will happen is whoever the attorney general is that Trump appoints could dismiss the case. Trump could pardon himself. You just don't know. But the case, if Trump wins, is not going if it doesn't go March 4th. Those are the stakes that are on the line. Period. Full stop. And today, it's just one more nail in that coffin with Tanya Chutkan having no choice but to have to pause the proceedings and pause all of any more pretrial work that would have to be done, including the juries, the sending out jury notices and jury questionnaires. All of that's paused while this gets litigated in the Supreme Court. Now, Jack Smith is also hedging his bets, and he filed a motion with the D.C. Circuit, the interim court, to hopefully, just in case the Supreme Court decides not to take it, he's sort of doing both at the same time, and he's asking both to expedite and to go fast. If you're, please take it and take it quickly. Now, the Supreme Court has agreed to take it quickly, meaning we will consider whether we are taking it quickly. And so December 20th is the date that Donald Trump has to file his response, not to the writ, meaning the writ is it's called a writ of certiorari, which is a request to the Supreme Court to take a case. And normally a request like that or a writ like that could take years, right? And what Jack Smith wants is this to happen quickly. So his first request is, will you decide whether or not to take the case quickly? And what they said is, yes, we will decide quickly. And so they gave Trump until December 20th to respond to is it okay, or what is your position, Trump, on whether or not we should take this quickly? Now, of course, he'll say, no, don't do it quickly. But either way, I think they will take it quickly. And then they will decide on whether or not there's presidential immunity, right? And so hopefully they'll do it really fast, like they did in Nixon versus Fitzgerald, like they've done in other cases as well. And we will still have our March 4th trial, but it's now December. So whether or not they will do all of this in 3 months is up for anyone's guess. Judge Chutkan had 2 limits on her order, on her staying order. So number one, the stayed deadlines and proceedings are held in abeyance rather than permanently vacated, meaning that if and when the case comes back to her, she will then decide whether to retain or continue the dates of any future deadlines, including the March 4th trial. So in other words, she's not saying everything she had there, like deadlines for motions, deadlines for other things, and the trial, she's basically saying it's not permanently vacated, it's just on pause, which I think is important. And I think Jack Smith knew this was coming, which is why he's been furiously filing all sorts of motions in the case this week. But it also, number 2, she says, this does not divest the court of jurisdiction to enforce measures such as the protective orders on discovery, the gag order, and the protective jury procedures. And she said, these items don't add any additional burden of litigation beyond those Trump already carries. And if a criminal defendant could bypass those critical safeguards merely by asserting immunity and then appealing them, they could irreparably harm any future proceedings. What is she saying there? She's basically saying, of course, my gag order still stands. And of course, the discovery protective order still stands. Otherwise, any criminal defendant, all they would have to do is just say, oh, I'm immune. And, and even if it's frivolous, and then appeal it. And at that point could just release everything, right? Release all the discovery, all the witness statements, say whatever they want. And she's basically saying, no, the law doesn't require that, just any future proceedings. And we're on pause until all of these things are decided because it's outcome determinative. So I'm sure the Manhattan DA's office is seeing this just like we are. And I'm sure they were already gearing up and preparing for trial as well. But now more than ever, and again, this is not based on inside information. This is just because I used to work there and I know how they are. I know that they are absolutely gearing up. And so for those people who said, oh, that's not an important case, the Stormy Daniels case, why that case? Why did that come? This case might be the single most important case of all because it has the best chance of going forward at this point. That case right now is absolutely one that he could be held accountable. Fani Willis in Georgia, she already said she asked for August. And so that's not going to happen for Trump because the election is in November. And the Mar-a-Lago documents case, he won the lotto when he got Judge Eileen Cannon. You know, there's no way she's going to have that case go in May. She's already indicated and signaled through all her various delays and rulings that that's not a realistic date, even though she hasn't said it outright. It's clear by reading the tea leaves what she has in mind. And Judge Chutkan, who was going to do this trial come hell or high water March 4th, potentially her hands are tied. Now, it's not 100% not going. Potentially, if the Supreme Court does this quickly, then this could go right back on track. But now that we have a Supreme Court with these individuals, these judges, these justices, many of which appointed by Trump, who have been rolling back the norms and rolling back the laws and ruling in ways that honestly I can't even predict anymore what they would do, just because they're really doing things in ways that are against tradition and against how the Supreme Court always operated. But we'll see. We'll see what they do here. But the Stormy Daniels case is going to turn out to be one of the single most important cases because it might actually hold Trump accountable. But we'll see. We'll see what goes and what happens. But stay tuned and stay informed. I'm Karen Friedman Agnifilo. Join me and my co-hosts, Ben Meiselas and Michael Popak, every Wednesday and Saturday on Legal AF.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.